The Nozell case takes the trend of criminalization forward in three important ways. First, it takes the statute and applies it in a very common sense way. There's not a lot of technicalities about hacking or other things. It just impresses people as saying, this looks like theft and we're going to prosecute it. So that's one trend. The second way it brings it forward is to really couple what's going on in the Computer Fraud and Abuse Act with what's going on in the Economic Espionage Act. And that's an important development. The Nozell case deals with both of them and shows that enforcement can be very effective. The third way that it brings forward trade secret law is to show that there is the availability of criminal relief, but all of these developments also apply on the civil side because the statutes have civil remedies as well. I, as an attorney representing private litigants, can bring forward claims very similar to what prosecutors do. We've seen more convictions in trade secret cases in the past few years in the criminal context for three reasons: changes in policy, changes in politics, and changes in perception. The change in policy was in 2013. The Justice Department actually formally announced and issued a white paper with their strategy for going after these types of claims. So we've seen more convictions after that. Second, changes in politics. People started to view these cases as not only injuring the economic interests of individual corporations, but it's really crimes against America and American citizens. The public support for these kind of cases has increased, and therefore prosecutors are more likely to bring these cases. Finally, the changes in perception. Corporations themselves felt like they should be coming forward because of the other changes in policy and politics, and they didn't feel like they had anything to be ashamed about. They came forward, and these convictions have resulted from these corporations doing that. The dissent in Nozell made three main points. The first point was that the court, the majority opinion, took the statute, the Computer Fraud and Abuse Act, beyond its anti-hacking roots, and the dissent thought that was inappropriate. The second thing was that the dissent felt that this effectively would make employers' use policies a sort of unannounced criminal code that was also improper in the defense view. And then finally, the dissent felt that this just gave too much power to private employers to influence criminal prosecutions, which really should be dealt with without reference to individual businesses' needs or desires as to the outcome of criminal cases.